And next, I shall propose a companion measure, the Equal Educational Opportunities Act of 1972.
The Nixon presidency has always been a controversial topic in American history, but despite the stain of Watergate, Nixon set in motion a turning point in women's rights whose effects would be visible decades later. This turning point was Title IX. Title IX is a short law, only 37 words long. It is as follows. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. President Nixon passed this law on June 23, 1972. At this time, second-wave feminism had emerged, set on track to become the strongest and arguably most impactful era of feminism. The civil rights movement was also making changes in law and society with Loving v. Virginia, Brown v. Board, and the passing of the Civil Rights Act of 1964. Before Title IX, there were no laws that specifically stated that discrimination based on gender was illegal, for women being treated as less than a man was the norm. Bernice Sandler, known as the godmother of Title IX, saw this discrimination in her everyday life. Before Title IX, women had to prove themselves to be as worthy as men to be educated, and typically needed higher test scores to be accepted into college. Scholarships for women, specifically in sports, were non-existent, and the NCAA didn't hold championships games for women's sports. The Civil Rights Act of 1964 prohibits discrimination specifically based on race, color, religion, sex, or national origin. Ultimately, Representative Smith of Virginia motioned to include women in Title VII of this law, and many male legislators laughed at the statement, thinking it absurd. However, the act was passed with gender included, creating a turning point for women's rights. Many cheered for the win, but Title VII was the only area in which women were mentioned. To get further insight, Title VII of the Civil Rights Act prohibited sex discrimination in employment, but didn't cover education, and Title IV prohibited discrimination in federally funded entities, but didn't cover gender discrimination. Despite the accomplishment, both of these legislations left many loopholes for women to be exploited because nowhere was it explicitly written that discriminating against women in educational facilities was against the law. Therefore, Title IX bridged the gap between these two legislations to specifically address discrimination based on gender in education. This was a huge turning point for women, but was met with much opposition, especially from those worried about the consequences this law would have on the budget of high-paying men's sports. But before focusing on opposition, it is important to look at the women who made this law reality. Patsy Mink, often referred to as the mother of Title IX, she was a representative of Hawaii and the first woman of color in Congress. She dreamed of becoming a doctor, something that she was ridiculed for simply because she was a girl. She could not stay in college dorms because of her race, and after graduation, she was rejected by every medical school she applied to. Some institutions specifically told her it was because she was a woman, which was typical as the number of women in healthcare in the 50s hovered barely above 6%, even though it had been a century since Elizabeth Blackwell, the first woman to be accepted in a med school. Mink persevered in internal law, instead running for political office. She won and then ran for Congress, but she lost. Her efforts did not go unnoticed as she was asked to make a speech at the 1960 Democratic National Convention. Patsy ran for Congress once more in 1964 and won, which prompted her to move to Washington, where she wrote Title IX, her most noted achievement to date. It was renamed the Patsy Mink Equal Opportunity in Education Act in 2002 following her passing in honor of all she did and wrote for the law. However, she was not the only person involved. For example, Edith Green, who was known as Miss Education, she authored multiple laws which were passed in the 60s and fought for women's equality, specifically in education, so working on Title IX with Mink was right up her alley. Or Bernice Sandler, a close friend of Green's who worked with her in the Women's Equity Action League to collect data on sexual harassment, which they then used to craft Title IX. Representative Edith Green began the hearings by saying, "Let us not deceive ourselves. Our educational institutions have proven to be no bastions of democracy," illuminating the injustice that occurred every day in what is supposed to be a learning environment for all. It took many hearings, but Title IX was in the final stretch, and after an arduous week filled with much opposition, Title IX was finally passed. This was a moment for celebration. Women had finally been given the undeniable right to equal treatment in education. However, this legislation was less than favorable to many on the defense of male athletics, saying that
women's sports certainly will be non-revenue producing, and naturally I do not feel like total budget should be split equally.
The ideology that women's sports are not as entertaining or worth as much money as men still stands today, but despite that, this legislation was an impactful turning point, especially in sports aspects of schools. Male sports' unequal budgets were suddenly taken from beneath them, and many tried to pass amendments, but few made it to the floor and none passed. That was until the Civil Rights Restoration Act of 1987. Or the Grove City Bill, named after the court case that created the need for this legislation. In 1975, the United States Department of Health, Education, and Welfare, now known as the Department of Education, implemented regulations stating that all educational institutions that are financially assisted by the federal government are to file a document assuring its compliance with Title IX. Grove City College is a religious co-ed school located in a small town in Pennsylvania. The college refuses federal financial assistance on grounds that it would compromise its independence. However, in 1976, around 7% of the students were studying on direct federal grants from the Basic Educational Opportunity Grant, or BEOG program. Because of this fact, in 1976, the Department of Education required the college to file the document showing that they were complying with Title IX. The college refused, and it was on this basis which the Department of Education withdrew the grants from the students. Grove City College and multiple grant recipients took a lawsuit to the Western Pennsylvania District Court with two main points: to reverse the termination of the students' grants and to not require a document of compliance from the college. 2 years later, in 1980, the court ruled in favor of the college, saying that although the grants do count as federal financial assistance, the department could not terminate the students' BEOGs. However, both the Department of Education and college pleaded to the United States Court of Appeals for the Third Circuit. This court ruled that because the college was a beneficiary of the BEOG grants provided to its students, it was covered by Title IX, and that the grants could be removed due to the college's refusal to file the required documents. The college then appealed to the Supreme Court, which agreed and in 1984 issued its decision. It was a 6-3 majority of the court held that when students receive federally funded grants, the Title IX requirements only applied to the specific program or activity that was benefited by the grants. In such instances, Title IX requirements do not apply across the entire institution. 4 years later, in 1988, President Reagan had the Civil Rights Restoration Act placed before him. He vetoed it. This act was meant to reverse the Supreme Court's decision on Grove City College versus Bell. His reasoning was that if he supported the overturning of this decision, this act would vastly and unjustifiably expand the power of the federal government over the decisions and affairs of private organizations. He instead proposed a bill which would exempt institutions which closely identified with religious organizations. However, both the House of Representatives and the Senate approved the Civil Rights Restoration Act, and it was put into effect later that year. This act was very important because without this act, the case would not have been overturned and the scope of Title IX would have been much more limited than it is today. In 1972, women with law degrees accounted for less than 10%, but in 1994, about 15 years after the implementation deadline of Title IX, almost half of law degrees were held by women. In 1972, only 9% of medical degrees were held by women, but by 1994, that number grew 6 times to 38%. Although intended for education, this legislation has had an immeasurable impact on sports from 1972 to the present. Athletes like Venus Williams have spoken about the positive effects this law has had on their careers and their lives. Title IX has thus been a turning point for women's education and their role in professional sports.